And this protected the Associated Press and other news organizations against business interference by competitors who copied and republished news stories immediately after their first publication. In the 21st century, examples abound of the clash between news organizations' desire to protect their own expression and the reality that much news is in the public domain. I will share just 3 examples. In a presidential campaign full of historic firsts and powerful symbols, no image was more important to Barack Obama in 2008 than the stylized red, white, and blue Obama Hope poster created by Los Angeles guerrilla graphic artist Shepard Fairey. My students have had a little bit of fun with that name, Shepard Fairey. I didn't bring the cartoon with me today, but a creative student drew a picture of a shepherd that had wings, and so. But this image, or a version of the image, was used by Time magazine when Time chose Obama as Person of the Year. Fairey's image of Obama also appeared on the cover of Esquire, among other places. And there was a lot of speculation about where the inspiration came for the image that Shepard Fairey created. The Philadelphia Inquirer was the first to identify what it thought was the source of this inspiration. And the Philadelphia Inquirer pointed out that there was an April 27, 2006 Associated Press photograph of then Senator Obama with George Clooney at the National Press Club in Washington, D.C. At first, Shepard Fairey said that he used this non-cropped photograph of Obama as the inspiration for his Hope poster. Later, Fairey admitted that he used a cropped photo of Obama. And it might not seem like a big difference, but this caused a little bit of trouble for Shepard Fairey in the lawsuit because he did admit that he misled his lawyers and the judge in where he obtained the photo. But he did obtain, apparently, this Associated Press cropped photo from Google Images and used that for the inspiration for creating the poster. And Fairey said that he did this because he was an Obama supporter, not because he was trying to make money. He did sell the posters for $45 each. Entrepreneurs lapped some of the posters up and resold them for thousands of dollars online. But Fairey says he was not in it for money, but rather for politics. And the Associated Press photographer who made this shot, and he does make that distinction, he doesn't take photographs, he makes photographs. His name is Manny Garcia, and he made this shot among thousands of others on April 27th, 2006. And in fact, he told National Public Radio that he didn't necessarily remember taking this particular shot or making this shot because he had made so many that day. Manny Garcia contends that he was a freelancer working for the Associated Press, and thus he, as the creator of the photograph, owns the copyright, and he didn't have a problem with Shepard Fairey's use of the photograph in creating the poster. However, the Associated Press claims that Garcia was an employee of the AP, and that makes a significant difference because employees under the work for hire doctrine don't own the copyright in things they create. Their employer does. And so Associated Press went to Shepard Fairey and his company, Obey Giant, and asked for compensation for copyright infringement. Fairey refused, and instead he launched a preemptive strike on February 9th, 2009 by filing a lawsuit in the U.S. District Court for the Southern District of New York asking for a declaratory judgment that his use of the Garcia photograph was permissible under fair use. The lawsuit is still pending in the Southern District of New York, and I think its resolution will help us understand the extent to which others may make use of copyright-protected online news under the fair use doctrine. Well, let me move to the second example. And first I'll say that one of the most significant changes in the history of copyright law occurred in 1998 when Congress passed and President Bill Clinton signed the Digital Millennium Copyright Act, abbreviated DMCA. Among other things, the DMCA prohibits and even criminalizes the circumvention of technological protection measures for copyright-protected works. In other words, a person could be civilly or criminally liable for sharing with others a software program that would help bypass copy protection on a CD or a DVD, for example. Most relevant for news is a prohibition in the DMCA on the removal of copyright management information that's found in 17 U.S.C. section 1202. Violation of this ban opens the door for civil liability, injunctions, and award of monetary damages. The DMCA itself defines copyright management information, as you can see here, but courts have struggled with this definition. Some have concluded that the DMCA prohibits something as elementary as the removal or alteration of a reporter's byline, the name of the publication, and the copyright symbol from an online news story. In one recent New York case, the Associated Press was allowed to go forward with a copyright infringement lawsuit against All Headline News, a website that rewrote or simply copied and pasted AP articles without permission and without including identifying information about AP as the author or creator of the articles. Interestingly, the court in this same case also resurrected the early 20th century hot news doctrine, which is a significant development. What remains to be determined under the hot news doctrine is exactly how hot news has to be. No courts really have ever specified how much time a news organization has to essentially have an exclusive right to publish a particular piece of news. Well, the third example is maybe a cautionary tale for journalists and journalism organizations, because this copyright management information claim in the DMCA can also be used against news organizations, and it has been used against news organizations. For example, on September 11th, 2001, a woman named Valencia McClatchy took a photograph of the mushroom cloud caused by the crash of United Airlines Flight 93 near Shanksville, Pennsylvania. Valencia McClatchy was not a journalist per se, but happened to be in the area and have a camera, and she took this photograph. As I explained earlier, no formalities are necessary for her to own the copyright in the photograph. She created it and owned the copyright from the moment of the photograph's creation. She titled this photograph "End of Serenity," and she sold copies locally for $20 each and donated most of the proceeds to the Todd Beamer Foundation. McClatchy also licensed the photograph for one-time use to several news organizations. 1 year later, an Associated Press reporter and photographer visited McClatchy to write about her experience with the photo. The AP photographer said that he wanted to take a picture or make a picture of McClatchy with "End of Serenity," but then the photographer also distributed a closely cropped shot of "End of Serenity," such as what you see here, that omitted both McClatchy and the copyright notice she had printed on the photograph along with her name. In a copyright infringement lawsuit, McClatchy convinced the federal district court judge that the Associated Press's conduct constituted removal of copyright management information in violation of the DMCA. Conclusions like this one pose significant challenges for news organizations today because, unlike fair use, the prohibition on removal of copyright management information is inflexible. It's also a very broad prohibition. In recent years, scholars have suggested that the news industry's push to enforce its intellectual property rights has been misguided. One problem with increased intellectual property protections for news is that it causes media companies to treat news as a commodity rather than a public service. The efforts to protect news through a digital rights management approach also have been criticized because they set up an adversarial relationship between news producers and consumers. And I'll have a little bit more to say about that in just a minute. So I pose the question, where should the news industry go from here? I'd like to conclude for a few minutes by discussing with you some thoughts about different possible courses of action for the news industry, some advantages and disadvantages relating to each of those. First, the news industry could follow the music industry's example and sue its own consumers. There could be aggressive litigation against websites like All Headline News, as there has been, but also perhaps news organizations could even sue bloggers and others who are perceived to use too much of a news story. And as I mentioned earlier, the Associated Press is kind of leading the charge in this direction.